Okay, let's talk about the Commerce Clause. When is the Commerce Clause an issue? Okay, first of all, as if you had me for common law, most of you probably did. Keep in mind the big question in constitutional law, right? Is can the government do that? And the answer to that question depends largely, the analysis implicated by that question depends entirely on what government you're talking about. The Commerce Clause, in terms of active regulation of commerce, we're not talking here about dormant commerce, okay? The Commerce Clause applies when Congress is your actor. So first of all, in terms of your red flag issue spotting, if you see a challenge to an act or proposal in the U.S. Congress, then it's likely that you're being tested on the Commerce Clause. We'll talk about in other videos. There are other things you can be tested on as well, but that is certainly one of the key possibilities would be a Commerce Clause. Why? Because the Commerce Clause is the major power exercised by the U.S. Congress. So how do you know it's a Commerce Clause question? Okay, now, so first of all, again, you have Congress as the actor, right? That Congress is the one being challenged. Its power is being challenged. Number two, what really triggers a Commerce Clause analysis is when you're looking at the activity that's regulated by Congress and you can't identify any specific textual basis in Article 1, Section 8. That's critical to cite that. In Article 1, Section 8, for Congress to act in that area. So, for example, if a fact pattern involves coining money or regulating bankruptcies or regulating copyright or immigration and naturalization, raising armies and navies, making rules regarding the conduct of the personnel in the Army and Navy, building post roads, right? If you're talking about one of those things, you don't need the Commerce Clause. I want to be very clear about that, right? There are specific textual authorizations in Article 1, Section 8, bolstered by the Necessary and Proper Clause, which you can always cite in one of these cases when Congress's authority is being challenged. But the Commerce Clause comes into play when it doesn't seem to be one of those things. So if you have a fact pattern where Congress is building post roads, you don't have to get into the Commerce Clause. Okay, you just say that's an enumerated power under Article 1, Section 8. Right, Congress is allowed to do that. So what triggers a Commerce Clause analysis? Number one, Congress is your actor. Number two, there's some kind of activity being regulated that doesn't seem to fall under any of the other enumerated powers. Congress's fallback in that situation is always the Commerce Clause. So you identify the Commerce Clause there as the probable major issue, and then you would have to identify the categories of activity that Congress is allowed to regulate under the Commerce Clause. The Commerce Clause empowers Congress to regulate commerce among the states. The categories of activity that can be regulated there would be channels of commerce, which would be the throughways, right, through which commerce happens, things like roadways, navigable waterways, things like that. Instrumentalities of commerce can be regulated. That's the second category. Now, be careful about this too. I've noted in some of the sample answers that I've looked at that the people who grade bar exams will credit you for saying not only the vehicles right through that use the channels, if you will, but also people in interstate commerce can be instrumentalities, right? So people or things, objects, usually vehicles, right, or vessels of some kind that use the channels of commerce, right, are instrumentalities of commerce. Now, most of the time, as in law school itself, when you see a bar exam question about this, you're not being tested on channels or instrumentalities. So you're given credit for identifying those as categories of activity that can be regulated, but then you move on and say, okay, those probably are not the issue. Why? Because the fact pattern is likely to have Congress regulating some activity, right? Not regulating roadways or regulating people traveling interstate. It could be, right? But or trucks or vessels, things like that. Usually, it's some kind of activity Congress is regulating, and that brings us to the third category of activity that Congress is allowed to regulate. So, again, we're painting in broad strokes here. Just get the general. Make sure you spot the issue, you get the general principles down, right, and you know how to attack this. So When it comes to the third category, that is activity, even if it's local, that substantially affects interstate commerce. So you would identify Lopez and Morrison as the key cases, the framework set up there, and go through a four-factor analysis. Number one, is the activity that's being regulated economic or commercial in nature? If it is economic or commercial on a macro level, right, wages, price controls, things like that, manufacturing, right, that's economic and commercial. So at a more micro level, is it some kind of financial transaction involved, sale, purchases, purchase and sale, that kind of thing. So you're looking at, is the activity economic or commercial in nature? If it is, it's more likely that the law would be valid. Secondly, you would look at whether there's a jurisdictional element or a jurisdictional nexus in the statute, meaning that it only regulates the crossing of state lines somehow, right? Like the lottery case, the interstate shipment of lottery tickets. I have a friend up north who says, remember this line when you're doing Commerce Clause analysis. If it crosses state lines, the law is fine. Okay, so that's if the law has some kind of jurisdictional element or nexus in it, meaning it only targets activity insofar as it crosses state lines, it's more likely constitutional under the Commerce Clause. Third, you would look at hearings and findings and analyze whether Congress linked, or did its homework really and linked its regulation of the activity to some kind of economic impact. And finally, you'd always look at attenuation, okay, as the fourth factor. And what is the relationship? Is there a direct relationship between the targeted activity and the economy? When you're doing your attenuation analysis, please remember to do aggregation. I've seen that in some of the answers, right? You can look at activity in the aggregate, assuming that it is economic activity. If it's not economic activity, get your points by saying, I can't aggregate here because the activity is not economic. So that is how you spot and attack a Commerce Clause question. Again, what triggers it? Congress is your actor, and when you read the fact pattern, nothing comes to mind, right, from Article 1, Section 8 of specifically enumerated power that would authorize Congress to do that. Its default position is going to be the Commerce Clause. You would run through that analysis. Do remember the most recent big-time Commerce Clause case was the Sebelius case, where the court made it clear that the Commerce Clause does not authorize Congress to force people into a market they didn't want to be in to begin with. So keep that in mind as well. Hope that helps. Next, we will talk about spending.